Hi, I'm John Skiba, and in this video, I'm going to share with you 3 tips on how to win your debt collection lawsuit. And if you stick around to the end, I'm going to provide you with a 4th tip that may be a real game changer in trying to win this debt collection lawsuit. But if this is your first time here on my YouTube channel, go ahead and click the bell and subscribe. That way you'll make sure that you'll get instant access to the most recent videos that I put out each and every week on how to deal with serious debt problems. Okay, in this video, I'm going to provide you with 3 tips on how to win a debt collection lawsuit. Now, when I talk about debt collection lawsuits, in general, I'm going to be talking about junk debt buyer lawsuits. Junk debt buyers are companies like Midland Funding, Portfolio Recovery, Unifund, LVNV, these large companies that go out and buy old charged off debts from companies like Wells Fargo, Chase, just your typical credit cards. However, even though I'm going to be focused on debt buyer type lawsuits in this particular video, the principles that I'm going to talk about are pretty much universal. And so if you're getting sued by an original creditor like an American Express, Capital One, this video is still going to help you out. Okay, now the 3 tips that I'm going to give you, I'm going to kind of take them out of order a bit. The first one I'm going to share with you is really a game changer. That is, I'm going to call this, be careful what you ask for. When I have people who come to my law office who are getting sued by a junk debt buyer or even an original creditor, and they've been representing themselves in the lawsuit, one thing that's pretty consistent amongst all of them that I see that they do is they often go and they put together a bunch of written discovery requests and send it over to the attorney for the creditor. And they're asking for things like, they want original contracts, they want the terms and conditions, they want monthly statements. And I totally understand where it is that you're coming from and wanting all of that information, particularly if you're being sued by a junk debt buyer, because you're in this situation where they didn't loan you any money, you didn't agree to pay them any money, yet they're suing you and they want you to write them a check, and they're coming at it with almost no evidence whatsoever. And so you're saying, hey, if you're wanting me to write you a check, you've got to provide this evidence to me. And so you're like, I'm going to force them to do it. I'm going to send these written discovery requests over to them. If they don't respond to it, I'm going to go in and file a motion to compel with the court. I'm going to force them to give me the information that proves that I owe this money to them. And the reason why I'm labeling this one, be careful what you ask for, is because you need to really, while I understand where you're coming from on this, you really need to look at how the court views this. And if you're actually hurting yourself by doing so much discovery. So the junk debt buyer, they come in, they're the plaintiff. You're the defendant. As the plaintiff, the creditor, the collector, the junk debt buyer, whoever it is that's suing you, they are required to prove to the court a number of things. One, they have to prove that you had the original account. They're going to have to prove the amount owed. They're going to show what the terms of the agreement were. They're going to show that you breached the terms of that agreement. And then they're going to have to show an additional step of how it is that they got it. They're going to have to show that it was transferred, assigned, somehow that they got this account, and now that's why they have the ability to collect on it, is because it was assigned to them. They've got to prove all of those things. Whereas you as the defendant, you don't have to disprove anything. You don't have to come in and prove that it wasn't you or prove that it was the original creditor and that they've got their numbers wrong. You don't have to do any of that. As the defendant, your job is really just to kick back and pick apart their case. They've got to prove all those things. And so if you come in there and request all these types of documentation, and I should tell you this, here's the dirty little secret when it comes to junk debt buyer cases. When they go out and purchase these huge portfolios of charged off accounts and they pay, 2, 3 cents, 4 cents on the dollar for them, the dirty little secret is they don't get a lot of documentation at that point. They might get a couple of statements or a generic bill of sale, but they don't get a whole lot of information or evidence that they can present to the court. And the reason why they don't care really is because 94% of junk debt buyer cases end up in a default, meaning that the person that they sued didn't even bother responding to it. Now, if a case goes through default, generally the court's just going to give them what they're asking for. They're not going to require them to come in with a bunch of monthly statements or really, parse through the assignment documents and make sure that they're the actual owners of it. The court's not generally going to require that. So from the junk debt buyer's perspective, they're thinking, why should we, why bother? Why go to the extra expense of getting all these additional documents when we don't need them, because almost everybody, 94% of these people, aren't even going to respond to it, and we're going to be able to get a default judgment. So that's why they don't have a lot. And so most of their contracts allow them to get additional documentation if they go back later and ask for it. They often have to pay extra for it, so they don't want to incur those extra costs. So if you come in, though, with a formal written discovery request asking for additional documentation, they may actually have to go back to the original creditor and get that documentation, even if they have to pay for it. And then they come in and they're providing you with years of monthly statements. They're providing you with the original contract or whatever it is that they're providing that they got from the original creditor. And in essence, you've kind of made the case against you, against yourself, if that makes sense. You went out and got the evidence that they're going to use against you. They didn't have it. They probably weren't going to go get it. But because you're forcing their hand with written discovery requests, they had to go get it, and now they are going to use it against you, and it's going to make your case a lot tougher. So remember your role, essentially, in this legal proceeding. You're the defendant. You don't have to prove or disprove anything. You can pick apart and punch holes in their case. They've got to come, though, and prove each and every one of those steps. Okay, second tip I'm going to give you on how to win your debt collection lawsuit. This one's going to be, I'm taking the, like I said, a little bit out of order. Let's go back to the very beginning where I cited that statistic that over 94% of these cases end in a default judgment. You have to file a response to the complaint. In most jurisdictions, if you want to avoid a default, you're going to have to file a written response to the allegations in the complaint. And if you don't do that, if you don't do that one step, and I've got a lot of other videos, I've got tutorials, I'll put little links down in the notes below this video. If you don't take that first step, which is one of the easiest steps in dealing with a debt collection lawsuit, you're going to lose. You're going to lose big. They're going to give them everything that they're asking for, and they're likely going to throw on some attorney's fees, court costs, and interest on top of it. And all of a sudden, this $2,000 credit card is going to turn into this $7,000 judgment. They're going to start garnishing your wages. They're going to levy your bank accounts and make life miserable. So answer the complaint. And like I said, I've got a lot of videos on this here on my YouTube channel. I've also got an actual tutorial where I walk you step by step how you do that. Make sure you do that. It's a fairly straightforward step. Make sure that you answer the complaint. That's the first step to be able to win your lawsuit. Third thing is another fairly simple thing, but a lot of people don't do, and it just involves showing up. In most of these cases, there's going to be relatively few hearings. There might be a trial, like in Arizona where I practice, there's something called a pretrial conference. Sometimes there are little hearings where they require you to show up to like a mediation conference. If you don't show up, most of these courts will enter a judgment against you. I can tell you, like in Arizona, the justice courts that handle most of these cases, they're just itching to get rid of these cases. They don't need another one of them. Thousands of them get filed in their courts every single year. They want this off their docket. And so if you don't show up, even if you're 5 minutes late, that 5 minutes may cost you big time. So make sure if there's any type of hearing set up with the court, whether it's over the phone, in person, however it is that they're doing it, make sure that you're there. On the flip side of that, if they don't show up, you should ask the court to hold them accountable. I do that all the time in my law practice, where if a plaintiff's attorney doesn't show up, I'll often say to the court, look, if my client didn't show, there's a good chance you would have either entered judgment in full or had some kind of sanction. So, turnaround's fair play. They need to be able, they should hold their feet to the fire as well. And many times you'll see that the court will do that. So those are my 3 really big tips on how to win a debt collection lawsuit. Be careful what you ask for. Don't go in and ask for a bunch of discovery. You don't need it. Make them prove their case. You don't need to prove it for them. Second one is to make sure you timely file an answer with the court. That's the first step to being able to get this thing dealt with. And the third thing is simply just showing up. If there's a hearing, if there's a trial, make sure you're there. Even if you're not sure exactly what you're supposed to say or do, if you're watching the videos on my YouTube channel, you're going to know what to say or do, but make sure that you show up. Okay, I promised you a 4th tip that's going to be a game changer. And that is, ask yourself, what does it mean to you to win the lawsuit? That's the title of this video, How to Win a Debt Collection Lawsuit. What does it mean to you to win? You need to know that in going in. Does win mean that, hey, I'm going to go to trial and this thing's going to get thrown out? And that's the only thing that's going to mean win to me. I can tell you I've done over 400 trials against junk debt buyers. I've handled thousands of these cases. And I can tell you that there are cases that we didn't go to trial and that we didn't win, where there was no judgment entered in favor of my client, that I consider to be a huge win. Because we settled it. We positioned the case in such a way that the case got a really good settlement. I've had cases where there's $40,000, $50,000 owed, and we've settled them for $5,000 or $6,000 or $7,000 or $8,000. Those are huge wins, even though we didn't go to trial and actually win the case. We positioned the case, we put some pressure on them, and then came in with a settlement offer and got the case settled for much less than was owed. You've always got to go back to and remember, they paid almost nothing for these cases. They want to get some money. You're trying to give them money and get this thing dealt with. If you're willing to do that, you can generally get a pretty good settlement. Now, part of litigating it is really just positioning the case for a decent settlement. And so by doing these things, by being careful with discovery, by filing an answer, by showing up to the hearings, often once a trial date set, a lot of these attorneys for the debt buyers, they don't want to do trials. They've got thousands of these cases going on, and the last thing they need is another trial that they've got to go to. So position the case by taking the appropriate steps. Don't let them get a cheap victory by getting a default judgment entered against you. And if you do that and define for yourself, what do you consider a win? If you're being sued for $10,000, if you could get out of this for $3,500, is that a win? Then position the case to where you can have those opportunities. So I hope that helps you out. Again, if you're dealing with a debt collection lawsuit, particularly from a junk debt buyer, I deal with them all the time. I put a lot of videos here on my website or on the YouTube channel. Go ahead and check those out. Make sure you subscribe to my channel because we put new stuff out each and every week that's going to help you with your case. Thanks for watching today.